Please get ready for a dictation of transcription number 356 and 357 from Sir Kailash Chandra magazine. 5 seconds. Start. Sir, even though the bill comes to this house for the first time, I had touched upon this subject in my budget speech in May last, and its principles figured prominently in the course of the general discussion on the budget. The two booklets explaining generally the new taxation proposals have also been circulated to the honorable members of this House. The House will therefore agree with me that it is unnecessary to cover the same ground in detail again in my introductory speech, especially as the various provisions will come up for detailed consideration later on. I will confine myself only to the changes that have been made in the original provisions of the bill in the course of its passage in the other House. At the outset, I should say that the broad principles of a tax on wealth have received warm support not only in the other House but also from a large section of the public, though there was criticism over some particular provisions also. I had examined the original provisions in the light of the criticisms and also representations received from various quarters, and such re-examination has only strengthened the justification for the tax. Sir, a tax on wealth is new to this country, but it is not new to the world. It constitutes a very vital element in the taxation systems of most progressive countries, particularly in the European and American continents. Its importance should not, in my opinion, be judged purely from its revenue content. I do not for a moment say that revenue considerations should be absolutely ruled out, as they are very important, but the real importance of the tax from my point of view lies in the fact that it facilitates the reorientation of the tax structure into an integrated pattern. It is not only a welcome supplement to income tax but also a corrective to it by which certain objectives of tax policy which cannot be achieved through income tax alone can be achieved through the combined operation of all the new taxes. Sir, in this connection, I may mention that there has been much controversy about the question of levying wealth tax on companies. The Lok Sabha went very carefully into this matter and came to the conclusion that having regard to the corporate structure in India, it is possible to exclude companies as such from the levy. As the House is aware, every individual Hindu undivided family and joint stock company will be liable to pay wealth tax. So far as individuals are concerned, the exemption limit is rupees 2 lakhs, and for companies, the limit is rupees 5 lakhs. No changes have been made by the other House in regard to the limit for these two classes. For Hindu undivided families, the exemption limit has been raised from rupees 3 lakhs to rupees 4 lakhs. At the same time, the next slab range has been reduced from rupees 10 lakhs to rupees 9 lakhs. Taking companies first, all companies, whether public or private and whether Indian or foreign, are liable to pay wealth tax. Ordinarily, a resident company will pay the tax on its total wealth, whether such wealth is held in India or outside. A non-resident company, however, will pay the tax only on its Indian wealth. Under Clause 45, certain companies are totally excluded from wealth tax. The bill, as it originally stood, excluded banking companies, insurance companies, and certain financial institutions sponsored by the central government. To this list has now been added shipping companies and institutions for the promotion of art, culture, commerce, etc., which are not established for the purpose of making profit and which are registered as companies for the sake of convenience of administration. Another important change is that wealth tax holiday will be granted to industrial companies for 5 successive assessment years immediately following the date of incorporation. This concession has been provided not only as an incentive for promotion of new industrial enterprises, but also with a view to avoiding any financial difficulty to such companies in the initial stages of their organization. The wealth tax holiday will also be extended to new industrial units of existing companies which are created by way of substantial expansion of the existing undertakings. As a corollary to the wealth tax holiday for new industrial companies, shareholders in such companies will also be similarly dealt with on the value of their shares for a like period of successive assessment years in which the companies themselves will be enjoying the wealth tax holiday. I may point out to you that because of the attitude of the mill owners of sugar factories of Bihar and Uttar Pradesh, there is an increasing demand among the peasants of these states that these sugar factories should be taken over by the government and run as public enterprises. As pointed out by our friend, even under the existing law, it is possible for the government to do so if the government so desires. Sir, yesterday I was making a point that so far as the present bill is concerned, it tries to make the nomination a simpler procedure than what was obtaining under the old act. The only difference is this. As I said in the beginning, after the last general elections, it was found that in certain areas there were a number of applications which were rejected on the ground that the nominations that were filed were not found in order. Therefore, there was a feeling at one time that we might provide for some procedure by which that matter could be taken to some independent authority. That was the proposal made by the Select Committee, which was appointed in respect of the former bill, which was introduced in 1953 and ultimately withdrawn. However, when this matter was again considered by the Select Committee on the present bill, they thought that if at all the judicial authority was going to be interposed at this stage, then the object of having simultaneous elections was likely to be defeated. It might easily happen. Suppose, in respect of a certain matter of disqualification, the matter was allowed to be referred to some authority. It would naturally be subject to the proceedings that might be taken under the powers vested in the High Court under the Constitution, or be subject to appeal to the Supreme Court. Therefore, the election program with respect to a general election would be set aside. Ultimately, it was thought that the best way to deal with the problem would be to try to obviate and eliminate as many chances of improper acceptance of applications as possible. Honorable members will find that the question of nomination for candidates is now made very simple, and there is practically no chance of any nomination paper being rejected, because it has been laid down in the Act itself that the returning officer shall correct if there is a mistake with respect to the number or some such technical mistake. As I said yesterday, we have removed the restriction as to the number to which one voter may subscribe. But the only thing that is now required is that there should be somebody to propose the name of certain other persons. There was also a proposal by some honorable members of this House that we might do away with that proposal also. Then the next question is with respect to his being disqualified on the ground that he was interested in government contracts or he was a convicted person and so many other things. In that connection, it was found that this was not a matter which could be summarily disposed of, and ultimately it has to be left, in spite of all that is said and done, to the election objection which may take place. But I am sure that a man who wants to stand as a candidate to the Legislative Assembly or a state or to the House of the People will naturally think twice before he applies. So that is the scheme so far as nominations are concerned under this Act. The next item refers to expenditure, and honorable members are aware that after the general election, practically every party and every candidate complained that the form of return of election expenses was so complicated that it was difficult for them to comply with it. In the first place, there were some overlapping items or categories. Naturally, when a man stood for election, it was found very difficult for him to find out whether the expenditure was on account of the clerks, messengers, this thing or that thing. It was therefore found necessary that the complicated form of returns should not be there. What is now required is that the man should only keep an account of what is spending, and there should be some ceiling on the expenditure to be incurred, because if there is no liability to keep an account, naturally the question of fixing a ceiling would be meaningless. It is from that point of view that some provision has been made in this bill to the effect that he should keep an account and ultimately he should file a copy of the record. As the honorable members might be aware, in one of the cases, it was thought that there was no fixed date from which the candidate should keep an account, and one tribunal went to the length of saying that the man should keep an account from the time when he offered himself as a prospective candidate. Now, that difficulty has been obviated by saying that that account should be kept only from the date on which the constituency is asked to return candidates till the date of their election. Stop.